The next and final case, Frank Fabiano versus Jerry Demings. We have a change of panel on this. Judge Evander is leaving us, and hopefully Judge Cohen is waiting in the wings. Like the weather's good. Living the dream. Hello, Judge Cohen. Welcome.
Judge Cohen.
All right, whenever you're ready, counsel. Good morning.
Good morning. May it please the court. I'm John Dill of the firm of Morgan & Morgan and represent Frank Fabiano. This case arises out of a proposed amendment to a complaint that was filed arising out of a cause of action that took place back in 2006.
On the battery, there's no dispute that the statute of limitations had run on that count, correct?
Well, the dispute is whether it relates back.
Whether it related back.
Yes, sir.
But standing separate, statute of limitations had run.
Standing totally by itself, that would be accurate, Your Honor.
And do you think the landscape changes once you get into a situation where the statute of limitations have changed?
Well, I don't know if the landscape necessarily changes, and I think that's part of the reason why the rule of relation back has to do with the same transaction or occurrence. Under 1.190C, if it arises out of the same facts, transaction, or occurrence, it relates back. And that makes sense because certainly things may change during the course of litigation.
Does it say facts, transaction, or occurrence?
Yes, sir.
No, it says conduct, transaction, or occurrence, right?
That's correct, Your Honor. I apologize. Conduct, transaction, or occurrence, which the conduct, in fact, in this case is, in fact, the same. Unlike some of the cases that have been cited.
Do I have the right complaint? I think I read your complaint. It was in a complaint that had, it said it had a count one, and then it went into the count, and but there was never a count two in it, right?
The original complaint?
I just want to know whether I have the complaint
I believe
that
so, Your Honor.
you sought amendment to.
Yes, sir. Yes, sir.
It was a one count complaint, but you had count one. You had it listed there, right?
Yes, sir. That's the way it was drafted. It was a count sounding in negligence, and the request for the amendment.
Well, it was labeled negligence, right?
Yes, sir.
Whatever it sounded in is really a function of what the facts, ultimate facts show, right?
That would be correct, Your Honor. I mean, what the ultimate facts in the case
If you
show.
hadn't had the label in there, you could have called it a battery complaint, right, without any problem.
I believe I could have done that, Your Honor, under the way it's pled. The change, what has changed as far as the landscape, it was the trial court's application of whether there could be excessive force use in a negligence case. And much like in the Trademore case where there had been a ruling and then a change and an appeal and then an attempt to relate back, this is just simply a change in the legal theory that's being pursued. The case law, and certainly the Turner versus Trademore case, says that if it's a change of the legal theory itself, that is not now a new, separate, and distinct cause of action. And the legal theory has to do with the acts of the person who committed this act. I would submit that the subjective intent of the defendant doesn't control whether this is a new cause of action or not.
Well, but if we look at the original state court complaint that you filed against the sheriff, you claim that he failed to use reasonable care to screen and hire people. I mean, that certainly sounds like negligence.
Correct.
That he failed to provide adequate training. That he failed to provide adequate supervision. That he failed to provide adequate protocols. I mean, that's all negligence stuff.
That is.
Battery is an intentional tort. Isn't that right? So, I mean, that's a completely different theory of recovery, an intentional tort versus a negligent tort.
I agree it is a different theory of recovery, and that's why the case law says if you're changing the legal theory of recovery, that is allowed. And that's why, as I was saying, the subjective...
How do you square that with the language that's in the West Volusia opinion that says an amendment will not be permitted when it states a new and distinct cause of action for from that set forth in the original pleading?
Because the West Volusia case was a new cause of action for familial consortium brought by a new party, essentially. In other words, the person who was bringing the complaint, this is a totally different set of facts.
Do I strike anyone when I'm negligently supervising them? Do I strike anyone when I'm hiring them inappropriately? There's no physical action. It seems to me that the conduct that is being complained about in a negligent hiring, negligent supervision is entirely different than the conduct that you're complaining about in the matter.
Your Honor, in the complaint also, and most importantly, was the conduct of the officer or the deputy himself, which was being put on notice of the injury, didn't act reasonably under that circumstance. That's essentially what the facts of the underlying...
I understand that, Your Honor. I know the basis of your statement.
So the difference is you can, again, getting back to the subjective intent, if the claim is that it's negligent, and then we take, let's say this for example, we have a claim about somebody who's running a red light, and we say they negligently ran the red light. And then we take their deposition and they say, I didn't negligently run the red light. I saw it was red, and I ran through it. Well, now there's the same occurrence, the same conduct, but now we have new facts. And if the statute has run in that, it certainly would be allowed under 1.190 to amend the complaint to add account for punitive damages in that case, or battery, or whatever is applicable, because it relates back to the same cause of action, the same conduct or occurrence. No different in this case. Whether he intentionally wrenched Mr. Fabiano's arm or negligently wrenched Mr. Fabiano's arm doesn't change the underlying conduct or the underlying occurrence.
Was the deputy a named defendant in the...
In the state court case, no, because under 768.28, he cannot be named individually if he's acting within the course of his...
Well, but that's a claim for negligence. Can he be sued for battery individually?
He can be if he's acting, as I allege, within the course...
Isn't he a necessary party?
He can be... We can't name him unless he's outside the course and scope of his employment under 768.28. The allegation is that this is within the course of his employment. Unlike in federal courts...
If it's a suit for battery within the scope of employment,
correct,
you don't have to name the deputy?
No, sir. In fact, I believe the statute does not allow him to be named if you're contending that it's...
No matter whether it's an intentional tort or a negligent theory.
That doesn't seem to be a distinction under the case law. And again, the intentional issue has to do just with that subjective intent of one of the parties. It doesn't change, again, the transaction, the conduct...
So to prove battery, you have to prove that there was unjustified touching by the deputy that was done within the scope of employment.
That's correct.
To prove the battery against the sheriff.
That's correct, Your Honor. That's correct. And that's simply what the request for amendment is. Again, under this facts, and we could have pled it in the original and the alternative, but I believe the facts could sound in negligence, but the court found that, in another ruling, that you couldn't have a cause of action for negligence incident to the arrest itself. So therefore, if there can be an intentional act incident to the arrest, which I believe the case law allows, that's why we would amend back. And again, all the cases cited by both at the trial court level and the appellant have to do with new parties, new causes of action. Again, as you said, the West Volusia case, certainly a new party. He's now bringing it not only in his representative capacity, but he's now bringing an individual claim for his own loss of consortium, which is much different. So that, I would submit for purposes of the rule, is in fact a totally distinct, new and separate cause of action.
I think you're just repeating yourself now. Why don't you take a break and let's hear from the other counsel,
Sounds like
all right?
good advice, sir.
And then you can use whatever time you have left at rebuttal. If you want to repeat yourself again, that's fine.
I hope not to. Thank you.
All right, sir.
May it please the court, I am Bobby Palmer representing the appellee.
Let me ask you this, Mr. Palmer. Let's just assume that they filed this suit that they labeled a negligence suit, and before the statute expired on either the negligence claim or the battery claim, you went to trial and the defendant prevailed. Could they have filed a new suit for battery?
I beg your pardon, Your Honor?
Could they have filed a new suit against your client for battery. You understand my hypothetical? They filed this complaint. It's labeled a negligence claim. And before the statute on either negligence or battery expires, the case is tried. Still within the statute of limitations on battery, they file a new suit against your client. Is there a defense based on res judicata?
Well, Your Honor, if the statute, if I understand Your Honor's hypothetical, if the statute has not run and the plaintiff goes to trial on the negligence claim,
And the defense wins.
right, could they refile under a battery theory within the statute of limitations?
That's my question.
I think they could, unless there's some res judicata issue.
Well, that's the question. Isn't it res judicata because it arises from the same transaction or occurrence?
Well, if it arose with the same parties, same issues, then I think that there could be an affirmative defense in the second suit that res judicata bars.
It's because, though, it arose out of the same transaction or occurrence, right?
Right.
Isn't that, I mean, does transaction or occurrence in that context mean something different than it does in the Rule 1.190 context?
Well, Your Honor, in this particular case, the issue is statute of limitations. And in this particular case...
Well, the issue is whether the amended pleading is based upon the same conduct, transaction, or occurrence set forth in the original pleading. That's the issue, right?
There's no doubt that it arises under the same transaction occurrence.
Okay.
As I understand it, the issue in this appeal is whether the relation back doctrine will allow a new, distinct, and different cause of action from that originally pled to relate back to the...
Let me ask you the hypothetical, a different hypothetical. All right. And let me, do you have Rule 1.190 there accessible for that you can look at it? Notice that it uses the word attempted in there. Okay. Let's say that the complaint in this case stated no cause of action whatsoever. In other words, they attempted to state a cause of action, but they fell short of that. All right? And then in an amended complaint, actually managed to state a cause of action. Why doesn't that relate back under the literal language of this rule if it arises from the same transaction or occurrence and it sets forth a cause of action that they attempted to set forth first time around? And why didn't it relate back?
Well, because if the amended complaint and the amendment is a new and distinct, different cause of action than the first...
Well, if the original complaint under my hypothetical stated no cause of action,
Okay.
there was an attempt to state a cause of action, but it was a failure to state a cause of action. How could the amended complaint be a new cause of action? There was never a cause of action to begin with that was stated in the original complaint. You understand what I'm saying?
It's my assertion that you could not amend the complaint. If the first complaint didn't state a cause of action within the statute of limitations, and after the statute of limitations runs, they attempt to state a cause of action, they are simply attempting to state a cause of action outside the statute of limitations.
So what does the word attempted mean in the language of the rule then, where it refers to something you attempted at first and now you're doing it correctly the second time around? Isn't that what they're talking about?
I still would assert, Your Honor, that if the original complaint failed to state a cause of action within the statute of limitations and a plaintiff seeks to amend his complaint outside the statute of limitations, it will not relate back. It's essentially an entirely new suit outside the statute of limitations.
All right, let me ask you this. If they had not included the label in their complaint. Lawyers like to label, causes of action. If they hadn't included the label but had just pled ultimate facts, and from those facts, those facts that were pled, the ultimate facts, alleged a cause of action for battery, would the amendment that labels it a battery be permissible or not after the statute runs?
No, Your Honor, they would have to allege the elements of the battery.
Well, I mean, but they did that, right, in this complaint. This complaint alleges every fact that constitutes elements of a battery, doesn't it? I mean, it says that the deputy went and arrested him and for no reason at all, pushed him down and broke his already broken arm, right? I mean, isn't that all you have to allege a battery? Is a intentional touching against the permission of the other person?
Well, if you look at the original complaint, I'm not sure they allege ultimate facts that would have supported a claim for battery, because their original complaint was based solely on negligence.
Well, I'm talking about the facts, because you know that, you understand that when we talk about pleading in a complaint, the responsibility is to put forth the ultimate facts. You don't necessarily have to name your legal theory. You can just plead facts. Isn't the factual basis for a battery cause of action contained in there? And if not, what facts are missing that would be necessary?
I would have to go back and look at the complaint, Your Honor, but essentially, the plaintiff only asserted a negligence cause of action in the original pleading.
You said that before. We're just talking in circles here. So let me move on to something else. Rule 1.170 relates to compulsory counterclaims. Okay, and it uses the same transaction or occurrence language. So if the plaintiff here and the defendant deputy got into a tussle, and they each, took a blow, so that the plaintiff sued the deputy for battery, and if the deputy wanted to sue for battery in a counterclaim, he would have to bring that as a part of this action, because it would be a compulsory counterclaim, because it arose from the same transaction or occurrence. You agree with me about that?
Yes, Your Honor, I agree.
Okay, so essentially really what that particular rule means when it's talking about same transaction or occurrence is that everything that arises from that incident must be brought in that one action, right?
Yes, Your Honor.
Okay. All right, sir. Go ahead with your argument. You answered my question.
You have any other argument you want to make?
I beg your pardon, Your Honor?
Do you have any further argument?
No, Your Honor. In closing, I would assert that based upon the West Volusia Hospital Authority case, which has been reaffirmed by this court in the Farnish-Found versus Straughter case, the plaintiff is attempting to assert a new, different, and distinct cause of action in the amended complaint after the statute of limitations is ran, such that every district court of appeal in Florida, including this court, has ruled that a new, distinct, and different cause of action will not relate back. And the appellant in their brief has acknowledged that that is the law, and the 11th Circuit Court of Appeals on the federal side has assumed that that's the law of Florida, and has held that every court in Florida has consistently held.
What is the purpose for the relation back provision in Rule 1.190?
Well, as I understand it, the relation back doctrine is a legal fiction that will allow the plaintiff to assert a cause of action outside the statute of limitations if it arises under the facts same facts and circumstances, but it can't be a new and distinct and different cause of action. This court, in the West Volusia case...
Okay, now, all right, now, let me just stop you there. Let's just take this a piece at a time, all right?
Yes, sir.
If a plaintiff files a suit that states a cause of action, okay, it doesn't need to be amended, right?
Right.
I mean, in other words, under what circumstances would the relation back provision in the rule come into play where it would actually operate if it's not to state a different theory arising from the same conduct? Can you give me a hypothetical where a plaintiff who has stated a cause of action would need to amend, and it would be critical that that amendment relate back to the original filing date?
Well, this court
You're going to tell me that it said that you can't state a new cause of action, and you already told me that, and I heard what you said, but what I want you to do is tell me what the purpose is of this rule if it's not to permit the relation back of a different theory of action arising from the same conduct that has already been pled.
Well, a different theory of recovery is not the same as a completely distinct and different cause of action. Nothing could be more different from negligence than an intentional tort. And so I continue to assert that in the cases from this circuit and from the other circuits where the relation back doctrine has been allowed to apply, it first has to be arise under the same facts and circumstances, but it also has to be something that is very similar to what was originally pled. In other words, the cause of action originally pled. In fact, the appellant cited some cases in their brief that I think are distinguishable, but where courts have looked at the amendment, looked at the original, and they have said, okay, is the amendment so different from the original such that it won't relate back? So there was one case where the original complaint was founded in a foreclosure of a mechanic's lien, and the amendment stated a slightly different cause of action, yet it was still based upon a foreclosure of a mechanic's lien. The mechanic's lien was attached to both the original complaint and the amended complaint, and the court said, well, it doesn't change the basic issues at trial, it doesn't materially alter the grounds for relief. Well, I would assert that a battery claim materially alters the issues at trial. At trial, under a negligence cause of action, the appellant would have to simply prove a violation of a standard of care, as opposed to an intentional tort, which is an intentional act. And in fact, this court in the Quilling versus Price case acknowledged the difference between a battery and negligence such that they are distinct and different torts. So, Your Honor, I don't want to repeat myself, but I think the court knows our position, and I hope I have answered all of your questions. I've tried to do so, but at this point I would close if the court doesn't have any other questions for me. I would close by saying that it is well settled in this district and all districts in Florida that an amendment may not be used to avoid the statute of limitations if the amendment sets forth a new and distinct cause of action. The intentional tort of battery cannot be more different than the tort of negligence. One is intentional, one is unintentional. I have nothing further if if you don't have any other questions.
Thank you, sir.
Thank you, sir.
Thank you.
I'll be brief, Your Honor. I did want to point out one thing. The answer filed by the defendant, one of the affirmative defenses was that the original complaint did not state a cause of action. So and then essentially that's what they traveled under as part of their summary judgment. And there's also, it seems unequivocal that it's conceded that it arises out of the same transaction of occurrence. So based upon the state of the rule and the case law, this is just a new legal theory. So other than that, I'll rest my prior argument.
All right, thank you all.
Thank you both. We will conclude our session for this morning. Have a safe trip home.